Hi, this is Phil Nash, the broker with Suncoast Realty, and I'd just like to quickly go through the as-is residential contract for sale and purchase, which we normally use in this company to write purchase contracts on properties. It is quite a lengthy contract. It's 12 pages long, and it is a legal document, and therefore your agent or myself really can't give you solid legal advice on the contents of this document. If you have any questions about the content of the document or don't understand any of the paragraphs, then the law does say that we have to advise you to go and seek legal advice from your own legal counsel. But let's just go through the very basics of this contract. This is a contract for you to actually offer to purchase a property. So initially it is an offer, and until we get all signatures on it and acceptance, it won't become a contract until every last signature is required. There are a lot of paragraphs on here relating to various aspects of the purchase of the house, and also there's a lot of dates that have to be adhered to. Alright, so let's just talk at the top here. We can see that we put the party's name, the buyer's and the seller's name. That's pretty self-explanatory. And the address, the county and the parcel number of the property, but also the legal description of the property. We do need to have the legal description. If you are requesting or the sellers are offering additional personal items that aren't covered in this list here, for instance ranges, refrigerators, dishwashers and so forth, then you may put in the extra items here. These are usually items which are, I spelled dryer wrong there, these are usually items which are not attached to the home. Anything that is attached to the home, screwed in, bolted down, or part of the structure, then that is regarded as real property and technically should come with the home. So you do need to be very, very careful when making an offer exactly what it is you want to be included in the home if they are indicating that it's personal property. And your agent will be able to help you with this. Also, if there are certain things which the seller says they are not including, or you do not necessarily want to be part of the purchase price, then you would have to put it down here as the following items are excluded. Here next we put in the purchase price. The purchase price is what you are prepared to offer the property and what amount of earnest money or down payment deposit you are willing to put in. This amount here has got nothing to do with the down payment that your lender requires if you are getting less than 100% loan. The earnest money is there to indicate to the seller that you are earnest about this offer and you are prepared to lose that money if for any reason that you back out of the contract for reasons not covered in the contract. We don't necessarily ask for that earnest money straight away. Usually we like to ask for it from you within 3 business days and get it to either the other agent or into an escrow account after the offer is accepted. If Suncoast is actually accepting your earnest money, Suncoast does not have an escrow account of its own, therefore we will deposit it with a title company or an attorney, and by law we are obligated to put in the details of that company where your escrow money is being held so that the seller will know where to look for it when the time comes. If you're obtaining financing, then you would put in the financing amount there. And then at the end of everything, when you have got your financing, you already have the $5,000 in escrow account, then you will have to bring to closing. This particular amount on this contract is $33,000. The time for acceptance, usually when we send a contract over, we would like to have it signed and accepted or countered within maybe 24 hours or 48, depending on whether it's a weekend, depending on whether the sellers are out of town and that sort of thing. So your agent will liaise with the other agent regarding what is an appropriate acceptance time, but normally somewhere between 24 and 48 hours. We do not want to have the seller think about it for too long and go chasing around for other offers which may be better than yours. Your agent will have tried to decide on the best closing date. For a cash deal, it can go quite quickly depending on what attorney or title company you're using or how it's being done. But if there's a loan involved, especially if it's an FHA and a VA loan, it can take up to 45-60 days. You need to speak to the lender to find an appropriate time. Generally, what I advise my agents to do is put in 45 days. This can be adjusted either earlier or later, depending on the circumstances. If the property does have a tenant in it, then we do need to see a copy of the lease so that we can inspect it. So there's a paragraph covering that. Also, if you are not sure that you are the one that is going to be buying the property, maybe it's going to go to a company, or it may be you and your wife, or you and your husband, or something you haven't quite decided yet. You may want to change your name to somebody else's. Then you have to decide whether you want to allow the contract to be assigned to somebody else or not reassigned. We normally put there, may not assign this contract, just to make it solid to you. Here we would tick whether you are paying cash. If you're paying cash, then you actually negate any financing contingency. Even if you are getting a loan, but you don't want this contract to depend on you getting that loan because you know you have it, or you want to make the contract very strong, then you would click check box A. But if you are obtaining a financing, then you do want to have a contingency in the contract that if you can't find financing, if the bank won't give you the money on the house because it doesn't appraise, or maybe your credit report and so forth doesn't allow you to get financing for this particular house or this particular amount, then we do want to be able to get out of the contract. So we would click this little box here. I haven't got it clicked here, I should have done. And then the agent, your agent, will want to see a letter from your lender indicating what type of loan, how long, and what percentage rate your loan will be when you get it. So it is important that before you actually send off a contract, a written offer, is that you do have a proof of your funds from your lender, or in some cases, if you're paying cash, you will require some form of statement from your bank indicating that you have the funds available. This really much depends on the seller's agent. The seller usually will ask for some form of proof of funds. And that's why we do encourage our buyers to get some form of loan pre-qualification before we start writing offers on houses. When it comes to closing, there will be certain things that have to be paid by either the buyer or the seller. The following the paragraph 9 here does actually indicate who is going to be paying what. And the choice that you have to make with advice from your agent is, do you pay for the owner's title policy, or does the seller pay for the owner's title policy? The agent will explain the purpose of the title policy, but a decision has to be made about who is actually going to be paying for the title policy on the owner's side. If you have a loan, then you will pay for the lender's policy as well. So your agent will explain to you about the title insurance policies. You may request, if you want, a warranty to be built into the closing costs, in which case we would have to put it there and who's going to pay for it. Under normal circumstances, it would be the buyer that pays for their own home warranty, but if you wanted it to be part of the contract and provided by the seller, or maybe the seller is offering it in the first place, then this is where you would put it and how much you are going to pay for it. If there are any special assessments due on the property by the local city for whatever they've done work in the neighborhood, on the roads and so forth, then they're either being paid up front or they're being paid monthly. Under normal circumstances, the seller will pay the installments up to closing, and then the buyer will continue paying after that. Okay, now we come to the very important paragraph in this offer and contract, and that is the right to inspect and cancel. We call it an as-is contract because theoretically you have gone in, had a look at the house, giving it your best inspection, and then you say, yes, I'm like this house, I'm prepared to pay this price for it, and on the basis that I buy it as is, or how I think it is as is. And then we have 15 days to think about the whole process. Actually, the wording of the paragraph does say that if the buyer determines in the buyer's sole discretion that the property is not acceptable, the buyer may terminate this contract by delivering written notice to the seller and getting your money back. Well, what this basically means is you've got 15 days to think about whether you actually want to continue with this purchase or not after the offer has been accepted. This gives you a chance to go in and check the house, have the home inspected, maybe check for flood insurance costs if it's in a flood zone, or home insurance costs, or termite damage, and so on and so forth. Within this time, you have to either make a decision to purchase a house, or maybe renegotiate the price because the inspection has revealed something that you don't like and needs to be fixed, or turn down the offer and contract and cancel the contract. But it's very important because after those 15 days, then you will be obligated to purchase the house. You do get to give a walkthrough inspection prior to closing, and this makes sure that the sellers have left the property in the condition that it was when you made the offer. Okay, let's just simply go now to right down to the end here, and we'll see that the final paragraph here says the buyer waives claims to the extent permitted by law. The buyer waives any claims against the seller and against any real estate licensee involved in the negotiation of this contract for any damage or defects pertaining to the physical condition of the property that may exist at closing under this contract and be subsequently discovered by the buyer or anyone claiming. In other words, what this is saying is the agents, they do their best to notify you, as the law requires, of any problems with the property that affect its value. But we cannot actually know everything. That's why we have inspections and leave that sort of thing to other people. Therefore, we do the best we can, but we don't know everything. We'll also include extra forms like a homeowners association form or maybe a lead paint disclosure if it is older than 1978. And at the bottom here, we would like you to sign under the buyer and the buyer there. And that is it. So that's the end of the contract. It's really important that you do understand this contract fully and understand it before you sign it. If you do have a problem, then contact your agent to see if your agent can sort out some of the questions you may have. Otherwise, you do need to go to an attorney or someone who you can rely upon for legal advice with regards to this contract. Thank you very much for listening. I hope I didn't take up too much of your time, and we'll talk to you later. Thank you. Bye-bye.